Good morning, all. We're here today for a return date hearing in the matter of CFI-022-2018 before His Excellency Justice Omar al-Muhairi. The claimant is being represented through video conference from ALNUAIMI and Company. The lead counsel is Rupert Reed, QC. Assisting is Rita Jaballa, Peter Smith, and Dipali Maldonado. The defendant is represented by Horizons & Co. Lead counsel Stephen Doherty.
Yeah, good afternoon, everyone. Mr. Robert, is my voice clear?
My Lord, you're very clear. Yes.
Okay, great. So just to make a tidy case, first of all, the two applications which you file on an urgent basis, in fact, the first one, I can consider it as an amendment of the current application for today, and the second application, which is a committal application, you're seeking to issue a committal order against Sheikh Khaled. My view is this: I want to postpone both application until outcome of today's hearing. Clear, Mr. Robert?
My Lord, yes, that indeed is the basis on which we I think both sides are moving. You'll see there is what is formally a continuation application. So formally, the return date proceeds on the basis of our application to continue the existing injunctions. We seek that they be continued until trial or further order. Clearly, the defendant has made an application, a challenge to jurisdiction. If the court, on the evidence on that application, and I should say we've only had the evidence yesterday, it's only been served on us yesterday, but when that application is properly heard, if the court were to find that the court had no jurisdiction, then that would be a further order which may or may not affect the continuing validity of the injunctions that have already been granted and which we say should be continued by the court today. In terms of the matter going forward, assuming the court does continue its existing injunction, we say that it should further give directions going forward for the hearing of all the outstanding applications. That's to say, first of all, the jurisdiction challenge, which needs to be heard properly on the evidence served, first of all, with us having proper notice of the evidence of the defendant, but also with the claimant having an opportunity to put in responsive evidence, and no doubt with the defendant then seeking to put in reply evidence. So that application needs to be heard properly on due notice and on the evidence. And in our submission, the contempt application should further be heard on that date, if not earlier. And my Lord, I'll address you as to why we say the contempt application should be made earlier. And also the application for further injunctions, for further injunctive relief, also needs to be heard. And we would submit that as a matter of good case management, assuming the injunction is continued, then all of those applications should be heard together on proper notice, with a proper timetable, and with the parties able to serve their proper evidence. So that's the marker. That's a marker, my Lord. If I can just put that down now. In terms of the return date today, I just want to apologise firstly for the number of files which I think your Lordship may have. There are, if I could just check what your Lordship has, your Lordship should have the original file which your Lordship considered when we made the application ex parte. It's a one bundle which may or may not be the bundle that the court marked up last time. Then there are two bundles. Bundles 1 and 2, which were filed by the claimants in anticipation of a hearing of all of the claimants' applications. And then there is in terms of then I should say there is a defendant's bundle. And then there are, which contains not only documents but also authorities. And then from the claimant side, there should be two authorities bundles. So that's where we are in terms of paper.
Okay.
And I should just say also, by way of housekeeping, I have with me in the room Mr. Jamie Randall, who's a pupil barrister who will be assisting me during the hearing, but he's not acting as such for the claimants.
No.
So here we are, my lord. This is the return date. The injunction was made by you on the 23rd of April and was served on the 24th of April. And your lordship, I hope, will have seen a procedural chronology that is provided in my skeleton, which sets out the dates and the timings of service. The injunction is intended to protect the school from various breaches of the side agreement and the shareholders agreement between joint venturers. And we say those are
Mr. Robert, sorry to disturb you. So I got your point in regard to today's application, which is a return date. So I prefer to start with Mr. Stephen, which represent Sheikh or represent the defendant, Sheikh Khaled. Then I will come to you for your reply, and I will give you my decision after hearing both of you. And if I need to do a case management, I'm willing to do as well. I hope this is the objective of the hearing today.
My lord, it is my application, it's my continuation application, so if I were able to go first, but I'm in your lordship's hands, I don't wish to.
I prefer to Mr. Stephen to start first as an retained date, then I will come to you after that.
Of course, my lord.
Sorry to, yeah.
I understand.
Thank you, Mr. Robert. So, Mr. Stephen, can you go first?
Definitely, Your Honour. I know a number of points have been raised so far in relation to case management. Would you like me to address the court on that now, or should we wait until the end? This is to address case management, so the next steps regardless of the outcome.
No, let's make it as an end. Start with your application. I believe you have two things. One, to set aside today the injunction application, and to adjourn the contest of jurisdiction application for further hearing.
That's correct, Your Honour.
Okay.
Well, dealing with the first of those, the defendant's request to set aside the injunction is based on the following reasons. First is that the claimants have failed in their duty to the court to provide full and frank disclosure at the ex parte hearing, which was on the 24th of April. Secondly, it's disputed that the DIFC courts have jurisdiction in relation to this matter. And finally, that the terms of the injunction have caused substantial prejudice to the defendant, and that the court should decline to continue the injunction on the balance of convenience. Have you received my skeleton argument?
Yes, before me.
I'm going to deal with matters slightly out of turn from how they appear in the skeleton, the reason being that the defendant's arguments in jurisdiction frame its criticisms of the claimant's approach during the first hearing. So I'm going to begin, it's at paragraph 11 of my skeleton, which is in relation to jurisdiction. In summary, the issues here are that...
Are you going to address the jurisdiction today, or just you touch it slightly?
I'm going to address the defendant's arguments in jurisdiction. It's our primary case that, based on these grounds, should not continue the injunction. But in any event, the claimant at the previous hearing failed to make full and frank disclosure of these arguments, and that alone is enough to set aside this order.
Okay.
The arguments are based on the following. The first is that the constitutional documents governing the relationship between the parties take precedence over the shareholders agreement and the side agreement, which are relied on by the claimants. And these documents provide that disputes shall fall under the jurisdiction of the concerned UAE Courts Department, which in this case is the defendant's submission as Ajman. The second reason is that the substance of this dispute to a large extent relates to alleged breaches of the lease agreement. Again, it's the defendant's position that that agreement is governed by the laws of Ajman and is subject to the exclusive jurisdiction of the Ajman courts. And finally, in any event, it's the defendant's submission that even if the DIFC courts could exert its jurisdiction over this dispute, it's highly likely that it would choose not to, based on the fact that the Ajman courts are the more competent courts to deal with this claim. And The upshot of those submissions in the defendant's case is, first of all, that there's no serious question to be tried, at least not before this court. Even so, any injunctive relief that this court is able to order can only relate to matters which are not dealt with either in the constitutional documents, so the Memorandum of Association, or under the lease agreement. And third, and importantly, none of these points were brought to the court's attention at the last hearing, and we say that these are the grounds on which it should be set aside for failure to provide full and frank disclosure.
Just recall from memory, last hearing, actually, the question was from the court itself.
That's correct, Your Honor.
To define the jurisdiction. And if I'm not wrong, the applicant take me to the three agreements. The first agreement was Memorandum of Understanding, signed or dated in 2015, in May 2015, and the second agreement was signed July 2nd and headed as the Shareholders Agreement, and the third agreement was Lease Agreement, and the fourth and last, and I can say this side agreement, it was signed on 2nd July 2015, which shaped the whole three previous agreements. And I believe the court was aware of the three agreements.
Your Honour, I should clarify, of course, what the defendant knows about these proceedings is what's available in the transcript and in the documents that were submitted to the court. The general thrust of the defendant's submission in this is that it's only upon being brought to the attention of the court by a learned judge that the MOA was discussed at all. It doesn't appear anywhere in the claimant's scale and argument in the hearing. There were a series of questions.
But I think if you go back to the hearing transcript, you will find the court was interfere in this point. Anyway.
Well, perhaps it might be easiest, Your Honour, if I deal with the relevant provisions the defendant rely on in the first place, and then I propose to come back to what our criticisms are of the claimant's approach at the last hearing. And the first agreement I want to draw specific provisions of to the court's attention is the MOA. Do you have the claimant's bundle?
No, I have the MOA before me. If you want to refer to the...
Yes, I want to refer first of all to the Memorandum of Understanding, which is in tab 4, and you'll find the relevant provisions are at page 23. You'll note that in the bundle there are two numbers. It's in the bottom right-hand corner.
Actually, if you take me to Memorandum of Association, there's no need to refer me to the bundle because it's...
Okay.
Yeah, in my...
Well, if I can ask you
take me to the...
Yes, it's... first of all, Article 22.
Okay.
And this is the article relating to disputes. And you note that what that article says is that in the event that any differences arise between the partners in respect to the liquidation of the company or about any article or clause of this Memorandum of Association, it shall be settled amicably. If no agreement is reached, then the concerned UAE Courts Department shall have jurisdiction to deal with such difference. Of course, this is a memorandum relating to incorporation of the company in Ajman. The relevant courts in this case are the courts of Ajman.
Mr. Robert, I believe this point not disputable, right? This is not under.
No, we accept that the memorandum is subject to UAE court jurisdiction. I mean, we do say, as you'll have seen in our skeleton, my lord, that the DIFC court is a UAE court, and there's plenty of DIFC authority for that. And we notice too that the wording here is the concerned UAE court. So, and looking at the Arabic again, it's the courts of the UAE with jurisdiction. And we say, of course, the DIFC min ihtisas. So we say that it is the DIFC court that does have jurisdiction by reference to the commercial agreements. But we accept that prima facie that it's arguable against us that there is a conflict between the MOA, the Memorandum of Association, and the commercial agreements on which we rely in alleging breaches against the defendant.
Okay,
but our claims are made quite specifically under the commercial agreements, my lord.
Thank you. Yes.
Your Honour, just commenting briefly on one of the points raised by my learned friend. The concern codes in this case, the defendant says, cannot be the DIFC. Similarly, for this memorandum, which relates to a company in Ajman, similarly it could not be the onshore Dubai courts. The concern court in question is, of course, Ajman. That's the defendant's position. Your Honour, the next thing I want to refer you to is Article 9 of the memorandum. If you go back a few pages.
Management of the company.
That's right, Your Honour. It's the defendant's position that Article 9 plainly sets out the relevant provisions regarding the management of this company. And I'm happy if Your Honour would like to read through these. In summary, what it says is that the director shall have all powers necessary for the management of the company. This would include representing the company before local and government authorities, to purchase business assets, to purchase goods on credit, to appoint and remove employees and fix remuneration, to represent the company before ministries, local authorities, to sign tenders, contracts, documents of a commercial nature, to open and close bank accounts, and importantly, at the end it also refers to the fact that the partners may issue a separate power of attorney in favour of the director.
Your point?
The point that we make about Article 9 is that one of the core disputes raised by the claimants in this case regarding the management of the company, the defendant's position is that the effective document that governs the relationship between the parties insofar as management of the company is concerned is the memorandum. It's not the side agreements, it's not the shareholders' agreement. And the reasons for that I'll take you to now. First of all, if I can ask you to go forward again to Article 21 of the memorandum. Article 21 provides, and I'm looking at its beginning of the second paragraph of that article, matters not provided for in this memorandum shall be subject to the provisions of the Commercial Companies Law and its amendments and the ministerial decisions made in the implementation thereof. This memorandum and any amendments thereto shall be written in Arabic language and notarized by the competent authority, otherwise this memorandum and amendments shall be void. Now, as I've said, the allegations relied on by the claimants, they say relate to the management of the company pursuant to the side agreement and the shareholders' agreement, and the interim relief was requested on the basis of the same. However, it's admitted that the reality here is that these all fall within the remit of the MOA. First of all, we have allegations regarding the withdrawal of the working capital facility. That's in Mr. Sharma's affidavit. Those may be properly framed as interference with powers of management under Article 9. Similarly, allegations regarding the withdrawal of powers of attorney, something which is explicitly dealt with again at Article 9. And further allegations regarding interference with government and other authorities. So, for example, allegations regarding to withdrawal of an educational licence with the Ministry of Education, allegations relating to labour issues. These all fall within the scope of Article 9 of the MOA. And importantly, the side agreements, the shareholders' agreement and the side agreement, both relied on by the claimant. None of these were attested, none of them were notarised, none were registered in accordance with the provisions of the Companies Law. And you'll see in the bundle I've provided the relevant provisions that we rely on. First of all, those are at tab 7, starting at page 6.
The Federal Company Law
Yes, Your Honour.
and Article 13.
The first I'm referring to is Article 10, bottom of page 6, but most of the text of it is on page 7. And no doubt you'll be familiar with these provisions, but Article 10.1 is the provision that requires that UAE partners in limited companies must hold 51% of the shares. And 10.4 provides that any transfers affecting the title to that percentage are invalid. Further down the page, Article 14.1 provides that the company's memorandum of association and any amendment thereof shall be written in Arabic and authenticated by a notary public. Otherwise, the memorandum of the amendment shall be null and void. And again, this is regarding registration, but Article 15.1, right at the bottom of page 7, says the company memorandum and any amendment thereof shall be registered at the commercial register of the competent authority so that the memorandum becomes effective. The word shall means that if it has not been registered, then simply put, it is not effective. Because of this, it's the defendant's position that the operation of the company's law mean that the provisions of the MOA take precedence over the shareholders' agreement and the side agreement, which were never formally effective. Any disputes, therefore, regarding the management of the company fall within the scope of the MOA and, therefore, by extension, the jurisdiction of the Ajman courts. In summary, our position is that the side agreement and the shareholders' agreement are irrelevant and void.
But do you think this both agreements is invalid with the third party, but between the parties of themselves on the agreement, is it still valid?
Well, Your Honour, the question isn't one of disputing the existence of the agreements or not. Here what we have is two agreements with conflicting provisions. The court has to make a determination on which one of those take precedence. And our submission is that the effect of the UAE companies law says that where such a conflict exists, then the constitutional documents must take precedence. So where there's a jurisdictional dispute, the jurisdictional provisions of the MOA take precedence over whatever is in the side agreement or the shareholders' agreement. And in this case, it means that this dispute is subject to the jurisdiction of the courts of Ajman.
Okay. My reading to the side agreement and the share agreement together, if I'm wrong, please correct me both. I can say that both parties, which is Mr. Sharma and the company, I will say global, then the company, its height, which is the school, come together and form a company. They called it a holding company. This as a point one. Point two, the parties of that company, holding company, because we don't have in the federal commercial law and structure for holding company, they came with this an idea to establish a holding company, contain the Sharma as an individual, then the company, which is a free zone, Ajman free zone company, plus the company, the school itself, Heights company, including Sharma and Sheikh Saeed's partner, or Sheikh Khaled, sorry, partner on that company. So can I consider this is a totally separate company than the school company, the Heights school company? Maybe it's complicated. I can explain it again if you don't understand me.
Your Honor, I think I understand the point. The defendant's position is that the only agreement really which matters here is about the management of the school company. That's what this dispute relates to. It's the management of the LLC. That's governed by Article 9 of the MOA. And we say that regardless of whatever contractual relationship exists outside that, there's a clear conflict between provisions governing the LLC and the MOA and anything else that governs it. But on application of the UAE companies law, the only agreement that's relevant for the court's consideration in this specific matter, which is the question of jurisdiction, is the MOA.
Okay. So to continue same question, because under civil law, we have a kind of this, we call it a civil company, not a commercial company. A civil company, the parties can establish a holding company. So you're saying that this is a different provision from the current case before me.
Your Honour, my understanding of the dispute is regarding Sheikh Khaled's alleged interference with the operation of the school, so in this case the LLC. And, for example, you can see in the terms of the injunction it refers to the powers of attorney granted in relation to the LLC. And in effect, it's about Mr. Sharma's position as director of the LLC. So, notwithstanding whatever the legal status may be with the holding company, this dispute is about the LLC.
Okay. Right. Continue.
And Your Honour, continuing on that, you've obviously referred to the provisions of both the side agreement and the shareholders agreement, but importantly there's a third piece of the puzzle here, in that we have the provisions of the lease agreement, which is the next document I propose to take you to. That's beginning at page 93, but I'll take you first of all.
The lease agreement is before me.
It is, so it's in the bundle we provided you. It's at tab 4. And the page I'm going to refer to first of all is page 113.
And which clause you want to refer me to the lease agreement?
It's clause 7 and 8.
Okay. Yeah, the jurisdiction clause.
Yes, the governing law and jurisdiction clause. As you can see, clause 7 provides that this agreement shall be governed by and construed in accordance with the laws of Ajman. Dispute resolution 8.1 begins in the event of a dispute between these parties, makes provisions regarding amicable settlement, and then 8.2 states that if the parties are unable to resolve a dispute through amicable settlement, then the dispute shall be subject to the exclusive jurisdiction of the courts of Ajman. Now, we would ask the court to do is to consider these provisions alongside the substance of what this dispute is about and what relief is sought by the claimants. It's also submitted that to a significant extent, the substance of this dispute relates to breaches of the lease agreement, which governs the central aspects of this commercial relationship, which ultimately is one whereby Sheikh Khaled is leasing the grounds of the school and the school's buildings, and that is then being operated as a business by Mr. Sharma. And if we look at the very specific allegations set out in Mr. Sharma's affidavit, we have allegations about failure to provide electricity connections. Well, if I can ask you to look at page 104, so this is clause 3.4 of the lease agreement.
Again, the clause?
3.4, headed utilities.
Yes.
Here you can see pretty clearly the landlord warns and represents that on and from the commencement date, all utilities, including but not limited to electricity, telecommunications, sewerage, water, shall be available in connection to the property. This, we say, is clearly a provision of the lease. Again, some of the allegations relate to failures to complete construction of school buildings. They arise in various forms, but again, if you can look first of all at page 93, which is the recitals page of the lease, those allegations regarding buildings, first of all, are that the initial school building that was supposed to be present on commencement wasn't there. Well, that's recital 1, which is in the middle of the page, at page 93, provides a warranty that the landlord is the owner of the land and building, more particularly described in the schedules to the lease agreement, as well as the building constructed on the land, Schedule 1, and the building to be constructed on the land in Schedule 2. And then if you skip forward to page 106, you'll find the provisions relating to an obligation to build an additional school building. So this is clause 3.7. It's at the top of the page.
The article again?
3.7.
Okay.
This says that the landlord will ensure that on or before the 31st of December 2016, the construction of the building on the plot identified in Schedule 2 is completed at the landlord's cost and expense and in accordance with the requirements communicated by the tenant. And again, this goes on, this is a common theme. Another of the allegations relates to encashment of post-dated checks. Well, I'm not sure there's any dispute between the parties what those checks were payments for, but it was for rent due for the lease of the school grounds. Any dispute, we say, relating to those post-dated checks is clearly something which falls under the payment provisions of the lease agreement. That's in clause 2, the set out in some detail. And again, the general allegations regarding interference with the school, this is the last clause as you look for in the lease, but it's clause 3.2. It's at page 101. And it's important to note that this is something that is expressly relied on by the tenants. And what it provides is that the tenant shall enjoy the property during the term without any unlawful interruption or disturbance from or by the landlord or any person claiming through, under, or in the laws of trust, the landlord. Your defence says that all of this means that this dispute falls, the allegations of dispute fall under one of two categories. One, they relate to allegations regarding the management of the school. The defendant says that is something that's provided for in the MOA and that supersedes whatever the provisions are in the shareholders agreement or the side agreement. Any of the allegations that don't fall in that management category fall under the provisions of the lease, which we say is the central commercial document that governs the relationship between the parties and what their obligations are. And accordingly, this court does not have any substantive jurisdiction to deal with those matters. And in particular in relation to the lease, we have the express provision that the exclusive jurisdiction is the Ajman courts. Your Honour, I want to address you now briefly on the comparative jurisdiction of the UAE courts in relation to this matter with the DIFC. I trust that this is something which you will be more than familiar with. I've included the provisions if you'd like to refer to them. I'm going to refer to Article 31 of the Civil Procedures Law. That's at tab 8 of the bundle at page 8. You'll see, just going through these and summarising, jurisdiction shall be vested in the court whose area the defendant has domicile. 2, any action may be brought before the court whose area the damage took place. 3, in commercial matters, jurisdiction will be vested in the court whose area the defendant has domicile, or the court in whose area management was made or performed in whole or in part, or the court in whose area the contract should have been performed. 4 makes provision that if there is more than one defendant, jurisdiction shall be vested in the court whose area one of them has his domicile. And 5, save in cases provided for in other articles of the law, it shall be permissible to agree on the jurisdiction of a specified court to determine a dispute, and in the event that jurisdiction shall be vested in such court, or in the court in whose area the defendant has his domicile, or place of residence, or place of business. It's the defendant's submission that, in this case, the Ajman courts can accept jurisdiction under pretty much any of those gateways. It ticks a box for everything. In particular, the defendant notes that SHEIKH KHALED is obviously a UAE national whose domicile is in Ajman. The claim relates to a school which is located in Ajman. The material agreements were concluded and, where applicable, notarized and registered in Ajman. The second and third claims are companies which are either established in Ajman or in the Ajman free zone. And the MOA and the lease both expressly provide that the disputes are subject to the courts in Ajman.
But the party can opt out from it, correct?
They can, Your Honour, under this law. My submission is that they haven't. The reason being that this dispute is about the lease agreement and it's about the provisions of the MOA. But in any event, the MOA supersedes any of the jurisdictional provisions contained in the side agreement or shareholders agreement under the company's law. By contrast, the gateway relied on by the claimants who bring this claim in the DIFC is one which is discretionary. It's something that the court may not accept. And I know Mr. Reid refers to the well-known case, Standard Charter, which relates to the FNC principle, but in our submission, this case really is very different to the one presently before the court. First of all, it's my understanding of that case that the DIFC had jurisdiction, and it was under Article 5.1, because the company was registered in the DIFC. That's not the case here. Here we have conflict as to jurisdiction. You've heard my submissions already on how that conflict should be resolved. But in any event, the relevant gateway that the claimants rely on is one where the court has granted a statutory discretion in that the court may choose not to exert its jurisdiction. This is different from asking the courts to rely on a general common law principle, in this case the FNC doctrine. So in summary, we say that notwithstanding Mr. Reid's submissions, that case doesn't apply in this dispute. And just if I can bring all of those points together, Your Honour, to make clear what the defendant's case is. First, for all of the reasons we've just outlined, our first submission that there is no serious case to be tried here, as it's highly unlikely that this court has or will accept jurisdiction over the substance of this dispute. And as such, the claimant doesn't have a prima facie case, at least not insofar as the dispute relates to the provisions of the MOA, the management of the company, or the provisions of the lease, which we say it does. Second, and specifically in relation to this court's ability to award interim relief, it's admitted that the court should not make any award where the relief requested relates to one of those agreements, i.e. the MOA or the lease, as those are subject to the exclusive jurisdiction of the Irish Mountain Courts. And looking at the terms of the injunction that has been granted, first of all, the injunction provides that the defendant has to stop interfering with the management of the school. In reality, we say that's a provision which is based on Article 9 of the MOA and Article 3.2 of the lease agreement, which relates to quiet majority of the property. Second, the injunction requires the defendant to allow the claimants to manage the school undisturbed and to ensure that all utilities remain connected. Again, we say that this is something which falls within both Articles 9 of the MOA, but also Article 3.2 of the lease agreement and 3.4 of the lease agreement, which relates to utilities connections. The injunction further requires that the defendant provide a notarized power of attorney for the benefit of the first claimant. This is something which is very clearly within the scope of Article 9 of the MOA, which makes provision about the creation of that power of attorney. And similarly with the injunction's terms relating to the ASIL facility, that entire dispute is something which arises from an interpretation as to the extent of the powers granted to the claimant under the terms of the MOA and also under the power of attorney, and more specifically, whether the MOA and the power of attorney allow borrowing. And finally, Your Honour, on the terms of the injunction relief, the post-tiered checks, we say, are pretty clearly in relation to rental payments, which we submit as obvious, falls within the scope of the lease agreement. And so it's the defendant's submission that even if the court were minded to continue some form of injunctive relief, that it should refuse to impose any terms which fall within the scope of those agreements. And importantly, Your Honour, that brings us on to the submission we dealt with briefly at the beginning, but can now turn to in more detail, which is that none of these matters were brought to the court's attention during the last hearing. Rule 2311 of the rules of this court provide that an applicant is under a duty to make full and frank disclosure of all matters relevant to the application. That includes disclosure of any possible defences that may be available to the respondent to the application, or put differently, there is a duty to make a fair presentation of the case, raising material points that assist not only the applicant but the respondent. And it's the defendant's case that there's been a wholesale failure to do that in this instance. First, the evidence submitted by the claimant didn't draw anywhere near sufficient attention to the fact that there were clear and obvious competing jurisdictional provisions. And whilst the claimants relied very heavily on the provisions of the shareholders in the side agreement, it's clear that they didn't draw the court's attention to the presence of the contrasting documents. We say that that's evident in the claimant's skeleton argument for the last hearing. For your reference, I'll take you to it. It's at tab 5.
In your bundle?
Tab 5 of my bundle, yes. Starting at page 3.
Okay.
I'm looking at section 2, right at the bottom of the page. There are provisions for the exclusive jurisdiction of the DIFC courts in each of, you'll see there reference to the side agreement and the shareholder agreement. What you won't see is any reference whatsoever to the lease agreement or to the MOA. And if you turn to the page, to paragraph 2.3, the claimant submits at the last hearing that, in the view of the express submission, SHEIKH KHALED, Avalon Global and Avalon Heights, to the exclusive jurisdiction of DIFC courts and the convenience of the DIFC as their jurisdiction of choice. And that it's this last part of the sentence which is most surprising in this context. There is no reason for the court not to exercise jurisdiction. We say plainly that's not correct. And turning then to what was discussed during the hearing itself, we say this is a continuation of what appears in the claimant's skeleton argument. So the discussion about jurisdiction begins at the bottom of page 3, which is at tab 6 of the bundle you have in front of you. And you already recall that there was some discussion here relating to the MOA, but that is entirely brought to the court's attention by the learned judge and not by the claimant. You can see right at the bottom, you obviously raised the point there regarding the MOA and the effect of the company's law. And as you go over the page, and I'll allow you to read this if you like, but if I can summarise, in response the claimant simply refer the court to the collaboration agreement, which it says supports its contention with the ICA's jurisdiction. Well, first of all, the defendant disputes the fact that the collaboration agreement is of any relevance to this question at all. But there is certainly no fair discussion of what the competing points are here. In continuing down, discussion is raised by the learned judge regarding the registration of amendments to the memorandum. Correct me if I'm wrong, my understanding is that what you were getting at with this line of questioning is which takes precedence. Is it the memorandum or is it the side agreement? And in response, the claimant alleges that the breaches relied on by the claimants only relate to the shareholder and the side agreements. And in fact, right at the bottom of the page refers to the laser-like focus of its application. Well, the defendant says that this is clearly not true. Even on the claimant's own case, the allegations relied on refer to the lease agreement, clause 3.2. And in any event, for the reasons we've already presented in the court, all of these allegations are caught by the lease agreement and the MOA. Again, I'm sure you've read Mr. Reed's skeleton argument for today's hearing. He seeks to rely on raising the matter at, it's at page 10, right in the middle of the page, and he quotes it in his skeleton argument. I'll read to you. He relies on it to say, look, we give the lease agreement a fair shot and pointed out the jurisdictional provisions. What we'd ask the court to look at is the entire context of the hearing transcript, which is some 27 pages, and which go to some extent to set out not just a summary of what's in the side agreements and the shareholders' agreements, but almost a term-by-term reference to what they relate to. The only reference to the lease agreement is this one section, which is in the middle of the page. It's beginning with just pausing there. There are a number of obligations in respect of acquiring other plots, in respect of works on the other plots that are not dealt with in the lease. And the lease is a document to which I won't refer very substantially, other than the expectation of quiet enjoyment. The tenant should enjoy the land. And the reason is that the parties on one analysis appear to have given thought to the proper law, issue of jurisdiction. So the lease, which is about real estate, which is about property, is subject to Ajman law, but all the contractual arrangements between the pure in persona personal contractual relations are governed by DIFC law, subject to the exclusive jurisdiction of the DIFC court. Well, that falls some way short of a fair assessment of what our case is. On any analysis, it's essentially a dismissal that the lease agreement has any relevance to these proceedings at all. And for the reasons we've already given to the court, we firmly dispute that that is the case.
So you want to say the core of the dispute is related to the lease agreement. That's it.
Yes, we do want to say that. We want to say that there was an entire failure at the last hearing of any of those matters to be brought to the court's attention. And so if I can just clarify your last comment, it's not only the lease agreement, but it's also the MOA, and specifically the management powers granted under the MOA. Just bringing that together, Your Honour, what we say is there has been pretty clear failure of the obligation to provide full fact disclosure in accordance with the rules, and that alone is enough to set aside this injunction order. Unless you have any further questions about that, I'll turn to the next aspect of my submission, which relates to the balance of convenience test this court applies.
Yeah, well.
The first comment that I'd like to make on behalf of the defendant is that in relation to the post-dated checks, the current form of the injunction order requires Lease to return, well, 2 points on this basis. First, that that's simply not possible. They're not in his possession. They're being held by Ajman Bank, and that's in accordance with the facility agreement, which was taken out to assist the construction of the second school building. And the second aspect of that is that it's not going to be possible for Ajman Bank to return these checks unless direct replacements are provided, and to date, there's been no attempt to provide those replacements. I know that the claimants have asserted that they provided a series of replacement checks, but what's important to note about that, and if you've seen Sheikh Khaled's witness statement, you would have noted this as well, those checks did not match at all. They post-dated everything by 6 months, which means there's an entire payment of rent that just wasn't paid. And as far as I'm aware, still hasn't been paid to date. The sum of, I think, 750,000 dirhams. To say that those are replacement checks is a fallacy.
And both checks are related to a lease or related to the fee, the return fee for Sheikh?
So the checks were provided under a facility, a loan facility that was taken out by the Sheikh, where he put up his own property as security, and the bank wanted to see some form of income to guarantee that. The loan was taken out so that the second school building could be constructed on the site. I believe the completion of that construction was in August 2017. So something that was already, the loan has already been taken, the work has already been carried out, but the checks are provided as effectively security for that.
As
what they represent is the
as a guarantee checks.
Pardon?
As a guarantee checks.
Yes. So it's a guarantee of the income under the lease. The second matter I want to address is the sale facility, and this is perhaps the one which causes the greatest potential prejudice to the defendant. The current form of the order requires that all steps necessary must be taken to reverse the freezing of that account. However, there are a number of pretty clear difficulties in doing that. The first is that in obtaining the sale facility in the first place, it appears that the first claimant has exceeded the authority granted to it under the MOA and the power of attorney. Neither of those documents allow loan facilities to be taken out. They don't allow borrowing. They make reference to opening and closing bank accounts. But I think it's simple to say that that is something which is very different indeed. And today it's not entirely clear how the facility was taken out. The second is that the defendant wasn't informed about the facility or the terms on which it was granted. And in particular, whether that facility places any immediate risk to the Sheikh or his property, in this case in particular, the lands and buildings of the school. which are owned by the Sheikh, and no assurance is provided whatsoever in that regard. It should be noted also that the side agreement, regardless of how one construes that, doesn't permit those risks to be adopted. Building on that, Your Honour, the sale facility also contains a provision. It seems that an assignment of the lease in favour of a sale finance is taking place. And I'll refer you to the relevant provisions. So this is tab 4 of my bundle and page 150. If you look about halfway down the page, it's point 7 provides for an assignment of the lease agreement between the school in favour of that sale finance. And I can take you to the specific provision of the lease if you like, but if you want for your note, clause 6.1 of the lease agreement states that any assignment of the lease must be with consent of the owner. And it goes without saying whether the Sheikh is unaware of this facility or the terms in which it was offered. Clearly, no consent has been given for that assignment to take place, and no such consent is received. Perhaps most importantly, the risk this poses to the defendant substantially arises one in the event of the claimant's default. In that the provisions of the side agreement and shareholders agreement are not going to prevent the defendant from being pursued by a sale finance for any personal liability he might have. In that, as far as they're concerned, the Sheikh is a 51% shareholder of the school in accordance with the MOA. It's pretty clear from the documents themselves that the only information given to the sale was the MOA. If you look, first of all, if you still have the facility pages open, it's at page 148.
The share agreement?
So page 148, what you'll have is standard provisions applicable to the facilities. It's the second page of the facility letter.
And will be in tab 4, right?
Tab 4, yes.
100? Page 100?
148.
Yeah, which article?
So it's the fourth row, information undertakings. It provides there that there's a requirement to advise a sale in writing prior to any change in the memorandum or articles of association in relation to its constitution, ownership, management of the company, and any amendments in relation to financing. A sale reserves the right to cancel, amend the amount of the credit facilities and or terms and conditions on which the credit facilities after assessing the impact of such a change. Clearly what that suggests is that as far as the sale is concerned, the document which governs the school is the MOA, it's not the side agreement. And that appears to be confirmed if you go over to page 151, which provides much the same. This is the conditions precedent to the grant of the facility, and it's in paragraph 2. It's provision of true copies of valid trade license, tenancy agreement, and the constitutional documents of Avalon Heights World Private School. Again, this is the MOA. The point is this: if Mr. Sharma doesn't repay or make any repayments under this facility and fall into default, there's simply nothing to prevent a sale finance from pursuing the Sheikh through whatever means they may be, whether it's an action through the DIFC courts, whether it's an action through the Ajman courts. And we say exposes the Sheikh to far too great a potential financial liability, and one that's not acceptable in the absence of any express provision that a sale are not going to have any claim against the Sheikh and they're not going to pursue it. So we say that this provision of the injunction causes undue prejudice clearly. Moving on, Your Honour, we also say that the terms of the injunction are excessively wide. The importance of this is that the claimants have to date, and you have noted from the applications before you, tried to use what are fairly broad terms of this injunction to prevent the defendant from validly exercising and pursuing his legal rights in the Ajman courts. And notwithstanding that the defendant doesn't accept that, albeit the terms are broad, we don't accept that that's what the interpretation is. But in any event, it's being used in that manner. Importantly, the defendant has brought a claim before the Ajman courts. In fact, brought that case before, as I understand it, this case was presented to the DIFC courts, and the wide provisions of the injunction are now being relied on to prevent any further pursuit of that matter, including references to appeal, as of course the Sheikh is entitled to do. And we should point out that although we don't accept that this is how the provisions of the injunction should be interpreted, if there is to be any form of ongoing injunction after today's hearing, those terms would need to be specific enough to make it clear that they do not cover what's being contended for, because effectively that is an anti-suit agreement. It's something that the defendant has, the claimant has asked for in a further application. So we would seek absolute clarity on that matter before we proceed. And finally, Your Honour,
before you move from, and which point name you want to refer and to amend?
well, Your Honour, we want the injunction set aside in its entirety. If the court has made its decision that it wants to continue subdividing terms, I'd be happy to provide submissions on what needs to be amended.
Are you ready now to do?
We think, well, Your Honour, we think at the very least, one, it has to remove any provision which is something which is called by either the lease agreement or the MOA regarding management. Obviously, we say that that covers pretty much everything under the injunction. But specifically, the things that come to mind are, one, provision of the POA, two, reversing the freezing of the sale facility, certainly in the absence of any written confirmation from the sale that it has been obtained against the Sheikh. Three, the provision of the checks. Not only because it's covered by the lease agreement, but also because they're simply not in his possession. And four, the provisions relating to connections to FEWA that clearly falls within the lease agreement, and that any further injunctions that would remain in place would have to make it very clear that they are without prejudice to the Sheikh's legal rights to pursue any redress available to him for either the DIFC courts or the Ajman courts or otherwise. This is not an anti-suit injunction. And finally, sir, on the balance of convenience, we say that clearly given the background to this case, and I know that submissions have been made as to Mr. Sharma's current position, I'm not sure entirely whether he's in the country or not, or what the status is. I would need to take instruction. But plainly, there is a high risk of either absconsion or simply, if there is a right of action that arises on the Sheikh's behalf against Mr. Sharma, there's a high risk that that is not going to be protected by undertaking damages. We say that it's likely that any damages would be almost impossible to enforce. And Your Honour, in any event, you've read Sheikh Khaled's statement. He clearly disputes that he has any risk to the school at all. This is something which has been a project of his for a long time, and he is determined to see that it's successful. His own daughter attends the school. He has no interest whatsoever in the school shutting down, coming to a halt, closing it. It's in our submission, this is nonsense. And we ask the court to take that into account when it determines its order today. Your Honour, those are my submissions on this issue. I do have some submissions to make on, regardless of the outcome, the directions that the court should set down for proceeding with this claim going forward. I'd be happy to make those now, or I'm happy to deal with that at the end.
At the end. I prefer at the end. I have one question regarding the Ajman Court proceeding. It's still going on, or the case is dismissed?
So my understanding, Your Honour, I think you have a copy of an English translation of this judgment.
Yeah, I got the urgent application which dismissed by the
That's right,
First
so
Instance
the
Court.
substantive application was dismissed, but is, as I understand it, currently under appeal. So those proceedings are not final, they are ongoing. What is final is that there was a decision, as you will have seen from that determination by the Ajman courts, that they accepted jurisdiction in regards to interim measures. And my understanding is that that aspect of the decision has not been appealed and is final.
So you suggest that if we accept the jurisdiction, then the next move will be Federal Supreme Court?
Your Honour, that may be the case. It's either that it's possible to make a reference on. So this deals with interim measures. So if I can deal with interim measures first, the Ajman Court has accepted jurisdiction in relation to interim measures. If the injunction is continued, I think there are very good prospects that this matter could be referred to the Supreme Court on the question of interim measures. There's a separate question then which deals with the merits side of the dispute, which, as I understand it, will require the court to make a substantive decision on, which is part of the application that's currently before the court. And once that application is made, then providing there is a similar finding in the Ajman courts, then that substantive matter could be referred to the Supreme Court.
Okay, what you refer to the contest of jurisdiction application?
Yes. Unless there's anything I can assist with further, Your Honour.
Thank you.
Thank you.
Yes, Mr. Robert?
My Lords, the claimants seek the continuation of the injunction to protect this school from various breaches of the commercial agreements, and that's how I'll refer to them. That's to say the side agreement and the shareholders agreement, which are commercial agreements between co-venturers. And we obviously make the point that under a commercial agreement, parties can decide where their disputes are going to be resolved and under what law their disputes are going to be resolved. And this court made a robust interim injunction, which I think Your Lordship has behind in Bundle 1. Essentially, the court required that the Sheikh should stop interfering in the management of the school. And you'll remember, my Lord, that the side agreement and the shareholder agreement reserve exclusive powers of managing the school to Avalon Global. That's nothing to do with the memorandum, nothing to do with the appointment of Mr. Sharma as an individual personal manager under the memorandum. That is about a right of exclusive powers of management of Avalon Global under the shareholders agreement and the side agreement. And you'll remember that what the Sheikh was doing was preventing staff from entering, leaving and working at the school and making statements to third parties that were untrue. That's what this court prevented, or sought to prevent, under paragraph 5 of the original order. Similarly, under paragraph 6, it took positive steps to allow the Avalon Global to manage the school pursuant to its exclusive right under the commercial agreements, the shareholders agreement and the side agreement. Specifically with respect in the agreement to the utilities, and the utilities, there's provision again in the shareholders agreement in clause 11.3 that those utilities should be provided to the Avalon Heights, to the school co, if you like, to the operating company. And there were then various mandatory steps which were required to be performed by the Sheikh. First of all, reinstating the power of attorney. And remember, that power of attorney was given under the side agreement and under the shareholders agreement, respectively clauses 2.4 and clause 11.12. Secondly, to reverse the freezing of the Asil facility, again, effected under the power of attorney that was made under the commercial agreements. And thirdly, in paragraph 7.3 of the judgment, to return the post-dated cheques, which had been used abusively and in breach of the Sheikh's duties of good faith, by which he presented both cheques on the same day in order to essentially cause all sorts of problems for Mr. Sharma, notably the travel ban, which has affected him until very recently. I should just say, by way of information, that Mr. Sharma is in the jurisdiction, he is in the UAE, so the suggestion that he's an absconsion risk is, in my respectful submission, untrue. His passport has been taken, and he's had to post bail, as I understand it, of 1 million dirham. So very little risk in my submission that he is going to be absconding at any point. Those injunctions, we say, were necessary to maintain the operation of the school in accordance with the commercial agreements. Now, before I respond to the detailed submissions of Mr. Doherty, I would like to make three brief points. Firstly, my Lord, there has been no compliance with the mandatory steps that are required under your Lordship's order of the 23rd of April. That is a clear contempt of court. There has been no reinstatement of the power of attorney. There has been no unfreezing of the Asil count. There has been no return of the post-dated cheques. The defendant, Sheikh Khaled, is in an extraordinary position. He comes to this court seeking the relief of this court when it suits him, but ignores other orders of this court requiring a particular mandatory action by him when it doesn't suit him. Now, we say it is trite law that an interim injunction is binding, even before the return date. That, after all, is why claimants come to the court and seek interim relief, even on an ex parte basis. And we say it's equally trite that an interim order made where there has been a challenge to jurisdiction is similarly enforceable pending a decision on or determination of jurisdiction. We say this is an order, the order made by the court on the 23rd of April is an order which commands the obedience of Sheikh Khaled, notwithstanding his defences, notwithstanding his arguments as to jurisdiction. And that is why the claimants have made their contempt application pending, which remains pending, but which we say direction should be made for it to be heard as soon as possible. So that's my first starting point, my Lord. My second is that the relief sought is only temporary, because as is known, there is a jurisdictional challenge. So essentially, my learned friend seeks to advance these jurisdictional arguments, notwithstanding that he knows that my client hasn't been able to put any responsive evidence on the issues of jurisdiction, and that the issue of jurisdiction will be heard, presumably shortly, on proper evidence and on proper notice. Mr. Ali Zarouni's statement was filed on the 5th of June, that's the day before yesterday. It was served on my client on the 6th of June, that's yesterday, at 5 p.m. Extraordinary conduct in seeking to serve evidence at the very last minute possible. Now, as I say, there will be an exchange of evidence. There will be, or there should be, a hearing. We say that hearing should be a day in length for the jurisdiction issues to be properly explored. Now, on that application, on that jurisdictional challenge, the issue will be, does this court have jurisdiction, and should it exercise that jurisdiction? Now, that application is not before this court, not least because the evidence in the application was only served on the claimants at 5 p.m. yesterday. What the court is dealing with today is the return date. And in other words, we say the court should keep the injunction in place pending a hearing of the jurisdiction challenge. Now, the defendant's case, the case that Sheikh Khaled essentially has to make is that there is no serious case that the DIFC court has jurisdiction. In other words, Sheikh Khaled is saying that it's not even arguable that the DIFC court has jurisdiction. And indeed, that's conceded by Mr. Doherty in paragraph 23 of his skeleton. Now, with the greatest of respect to my learned friend, that is an untenable submission. The idea when there are a number of breaches alleged of commercial agreements which are subject to DIFC law and subject to the exclusive jurisdiction of the DIFC courts, that it is not even arguable that the DIFC courts have jurisdiction, we say is a very bad submission. And on one analysis, that's as far as this court needs to go. I should say, curiously, in terms of strategy, it's clearly the continuation of the injunction has a temporary effect. But I note from paragraph 35 of my learned friend's skeleton that he's suggesting that the decision today on jurisdiction for the return date, not on the application, but on the return date, may dispose of the proceedings in their entirety. So there is a clear intention on the defendant's part to knock out or to deliver a knockout blow on jurisdiction without a full hearing and without the claimants having been able to put in evidence. We say that is a highly dubious strategy, and it's one that's underhand, and it's not one which the court should entertain. And we note, too, in respect to the skeleton, that it was drafted before your Lordship's decision last week on the timetabling of the other applications. That much is clear from paragraph 35 of the skeleton. So this skeleton has been ready since last week, and yet it was served on my client yesterday, indeed midday yesterday. And we suggest that this is an underhand strategy which should be rejected by the court. Thirdly, by way of starting point, we say when one looks at the opposition to the continuation, as eloquently set out by my learned friend in his oral submissions a moment ago, it's based on the duty of full and frank disclosure, it's based on the issues, the narrow issues of jurisdiction, and it's based on balance of convenience. It's more important, perhaps, to know or to notice what it's not based on. There's no attempt made to deny any of the conduct of Sheikh Khaled as alleged by Mr. Sharma. There is no attempt to deny any of the breaches of the side agreement and the shareholders agreement. All that is said is they may also be breaches of the memorandum of association, and they may also be breaches of the duty of or the right of uninterrupted enjoyment under the lease. So in our submission, the court is entitled to assume, for today's purposes, that those breaches of those agreements, that those agreements were so breached. No attempt has been made to deny those breaches, and indeed one suspects, I would infer, that the reason that no attempt is made to deny those breaches is because they're true. Mr. Sharma's account of what happened on the campus of this school, what happened in terms of the attempted interference with the management of this school, did in fact occur, as is set out in Mr. Sharma's witness statement, and as underlies the judgment that was made and the injunctions that were made by this court last time round. And I should say, too, there is no attempt made to challenge the validity of the nominee arrangements. And your Lordship will remember we had a lengthy discussion last time about the issues that arise between, on the one hand, memoranda of association of UAE companies which require 51% shareholding by a local partner, and on the other hand, nomineeship arrangements which appear to make the 51% held on trust, and whether there's a conflict between that and how that conflict is resolved, and how by inference the conflict also should be resolved as between jurisdiction clauses and choice of law clauses in the memorandum and indeed in the commercial arrangements, the side arrangements, if you like. Those are very difficult issues. To suggest that my client's position on jurisdiction arising from that conflict is not arguable is, as I say in our submission, a very bad argument. There is no authority on this point. If the court, on the jurisdiction agreement, on the jurisdiction challenge, or at trial, gives judgment resolving the conflict between memorandum of association and side commercial agreements and any conflict between them, that would be a landmark judgment in the DIFC. But that issue is not put before the court today. It's not a point taken by the defendant, Sheikh Khaled, in seeking to resist, to oppose the continuation of the existing injunction. So those are my three starting points, if you like. In terms of corporate structure, it is, as your Lordship suggested, quite complicated. Essentially, one has the school itself is owned by Avalon Heights, which is an Ajman company. That's the third claimant. And then the majority shareholder is Sheikh Khaled, 51%, him being the sponsor, in accordance, as your Lordship seen, with Article 10 of the Commercial Companies Law, which we all know well. But he holds those shares as nominee for the minority, the 49% shareholder, which is Avalon Global, which is an Ajman free zone company, and that in turn is owned by Mr. Sharma and his daughter. So the memorandum of association in question is that of Avalon Heights, the third claimant, which holds the school and is an Ajman company. Now, when one looks, and your Lordship will remember, because we had this discussion because your Lordship raised the very issues of jurisdiction which my learned friend has sought to canvass this morning. But when one looks at the Memorandum of Association, it is very much a document dealing with corporate issues of corporate governance. These sort of bylaws, memoranda of association, articles of association, the constitutional documents of a company are universal. They appear in almost any jurisdiction in any developed country which has companies, because clearly third parties who are dealing with companies need to know the authority of the person with whom they're dealing. You have constitutional documents which are registered, which are accessible to third parties, which allow a third party dealing with the company to know what are the internal procedures of the company. And that, we say, is what is in this, the Memorandum of Association, the Acta Assis, which is formed as a contract, as an acta between Sheikh Khaled and Avalon Global. And in a huge reliance is placed by my learned friend on Article 9. But Article 9 just is essentially the appointment of Mr. Sharma as a manager. It's not dealing with the exclusive powers of management that arise very clearly under the side agreement and the shareholder agreement. And Article 22 deals with the jurisdiction of the UAE court. We say that includes the DIFC courts, and we'll come to the authority for that in a moment. The side agreement deals with the nomineeship and with the obligations of good faith, both of which are major parts of the claimant's case. You will have seen, my Lord, the particulars of claim that are exhibited to the application. All of the breaches alleged in the particulars of claim are breaches of the side agreement and breaches of the shareholder agreement. The side agreement, we say, is a very common arrangement whereby the sponsor, the local partner, holds 51% of the shares on trust. Now, I've mentioned the conflict issue. I've mentioned the fact that many investments by foreign investors are written in this way with a side agreement under DIFC law, because the DIFC has a trust law, so it permits nomineeship, it permits trusteeship. And as I've said, if there were any decision on this, it should be a decision on proper authority by reference to the principles, on evidence, by a court with the parties having proper notice and not having evidence served on them the day before. Not an issue to be taken by the defendant on this at this return date, and indeed it is not an issue that is taken by the defendant on this return date. The shareholder agreement we've looked at before, my Lord. I'm not going to take you to detailed provisions again, but in essence there is a strong provision against interference by the sponsor in the management of the company. Now, my learned friend sought to conflate that with the right of uninterrupted enjoyment with property. But it isn't. It's very clearly focused on interference of management in the company. And that is why we say, that's why the breach is pleaded by reference to the shareholders' agreement, and that is why we say the exclusive jurisdiction clause in the shareholders' agreement is the relevant jurisdiction clause for our purposes. As your Lordship pointed out, there is an opt-in to the jurisdiction, to the DIFC jurisdiction. That's plainly permissible as a matter of DIFC law under Article 5A2. It's also permissible, we say, under UAE law, and my learned friend took you to Article 31.5 of the CPC. Can I just take you briefly back to that? This is tab 8, paragraph 9, in my learned friend's The Defendant's Bundle. And just in terms of the wording, when one looks at 5, save in the cases provided in Articles 32 and Articles 34 to 39, none of which are relevant, it shall be permissible to agree on the jurisdiction of a specific court to determine a dispute. So the parties are permitted to decide a jurisdiction. And in that event, jurisdiction shall be vested in such court, or in the court whose area the defendant has his domicile or place of residence or place of business. Now, the language of that provision in Article 31.5 is plainly mandatory. It shall be vested in such court, i.e. such court as the parties have decided in accordance with their liberty to decide. So there is the opt-in. It's there in terms in the in Article. It's consistent with Article 5 of the Dubai Judicial Authorities Law. It's also, we say, entirely consistent with the CPC, the Civil Procedure Code, Article 31(5). Now, again, we could go to the lease, but my learned friend took you to the exclusive jurisdiction clause. It's a very unsatisfactory exclusive jurisdiction clause because, as you'll have seen, it provides for the jurisdiction of the courts of, and then in square brackets, Ajman, close square brackets. So it doesn't really look as if there's any positive choice by the parties. It just looks as if a standard form document has been used. We're not going to. There is potentially a case in rectification that the lease needs to be corrected because it doesn't, in fact, reflect the true intention of the parties. It just simply reflects a standard form document. But in any event, we accept that under Article 32 of the CPC, with which your Lordship will be familiar, and which we have, again, tab 8 in my learned friend in the defendant's bundle, that is dealing with actions in respect of real property. And if your Lordship wants to turn that up again, defendant's bundle, tab 8.
Yeah, let's go ahead. I'm aware of that article.
Okay. In actions in rem, in respect of real property, and actions for possession jurisdiction, shall be vested in the court in whose area the real property, or part thereof, is located, in the areas or more than one court is located. So these are actions in respect of real property. So where one is dealing with property, real property rights, rights to land, or real property issues, then under the CPC, that is a matter for the court of the place of the relevant property. We say, however, that the rights in question are not property rights. The rights we are dealing with are the rights under a commercial agreement. And to correct myself, what we're saying is it is arguable that the rights in question are rights under the commercial agreement. The test we have to satisfy in defending this injunction is low. It's just that there's an arguable case that we have jurisdiction because the relevant rights are commercial rights arising under commercial agreements. They're not real property rights, which would be subject to the jurisdiction of the Ajman courts under the CPC. Now, in terms of the jurisdiction of the DIT courts, my Lord, on the last occasion we looked at the court law and we looked at the law of damages and remedies. We may not need to go back to those provisions. Essentially, under DIFC law, there is no distinction between negative and positive injunctions. So one can approach a mandatory injunctions, for example, the reinstatement of the ASIL account or the provision of a PO at the power of attorney. Those injunctions are as forceful and as effective as negative injunctions against Sheikh Khaled's interference with the management of Avalon Heights. In terms of the tests, I've mentioned already that the critical test is whether there is a serious question to be tried. Where you're granting an interim injunction ahead of trial in order to protect the position, hold the ring, all the court has to be satisfied of is that that there is a serious question on the claimant's claim. And we say that extends to jurisdiction. So is the claimant's case on jurisdiction arguable? And in our submission, the answer to that is plainly yes. The second test is balance of convenience, which is essentially weighing the prejudice. So if I make the order, if I injunct the defendant, what will be the prejudice to the defendant? If I don't make an order, what will be the prejudice to the claimant? Well, we say, in this case, the prejudice potentially to the claimant is that the school in which they have invested, I think, more than 15 million dirham, that investment will be completely destroyed. The school will be destroyed. The staff will leave, the students will leave, there will be, the business will become entirely unviable. This is a business which is relatively new. It has to date made losses of 8 million dirham over 2016 and 2017. It is this year finally reached pupil numbers for September 2018 of 750. It is beginning, it's just breaking into a position where it is viable and where it is starting to make profit. To destroy the viability at this stage of the development of a school would, in our submission, be catastrophic from the point of view of the claimants and the investments that have been put in by the claimants. We know from the Mumbai school that the model has been hugely successful. We know from the audited accounts that the initial losses have essentially been reversed. I don't know if your Lordship has in Bundle 1, it's possibly worth looking at those now. So the claimants bundle, Bundle 1 at tab 6. And if I could take your Lordship to page 277 in that bundle. And while I'm here, if I could start at 275, so that's the statement of financial position. You'll see that
275.
275. This is the statement of financial position.
Sorry to interrupt.
1 minute, Mr. Robert.
Sorry to interrupt, sir. The bundle I have for today's hearing bundle, I didn't have a page 277. Can I just clarify which you were looking at?
There are two bundles that were filed by the claimant.
Yeah, so I have two sets of bundles with 2 volumes each. The first is hearing bundle for 7th of June, and I've been served this morning with another 2 bundles. So could you have a look at the front page and let me know which bundle would assist? Thank you.
Hearing bundle for hearing list is 7th June 2018.
Okay.
Okay, and I've got a tab 6. You got a tab 6? And my tab 6 starts with the collaboration agreement.
The collaboration agreement, okay. I've got that in.
Yep.
Thank you.
And if you turn on to, and I'm looking at the bottom centre number, if you turn on to page 275,
Okay.
there you have the statement of the financial position. So that is essentially the balance sheet, and that shows that you'll see the most recent year, August 2017, the balance sheet, the total assets are 10 million dirham. So we'll come back to that, but for now, if one turns on to page 277, one has the profit and loss. And there you'll see that the losses made in the year to August 2016 were 6 million dirham, and then in August 17, 1.7 million dirham. So this, as I say, is a school that is beginning to get to the point where it will turn a profit. It has now got, for September 2018, 700 students. 90% of those students at the school are Emirati or Arab. This is not a school provided for expat children. It is a school which is providing a valuable service to children in Ajman, to both Emirati and Arab children in Ajman. The constraints on the success of the school have to date been that the success that the school has had have been enjoyed notwithstanding and in spite of the constraints arising from the delays which are set out in Mr. Sharma's witness statement. Now, my learned friend in his skeleton sets them out in considerable detail because they seem to relate to have property relations. They are pleaded by way of background. So the delays by Sheikh Khaled in providing utilities, the delays in acquiring the 3rd plot, the delays in building the 2nd building, those failures are not the breaches that are pleaded in the claim and which we rely on as part of our claim. Those are the background in terms of the general conduct of Sheikh Khaled and why we needed to come to court to seek the injunction. Now, the breaches, as I've said, we will be relatively familiar with. I will run through them relatively quickly. not least because they are not denied. There is no attempt to push back or to argue that such breaches did not occur. The first breach was the presentation of a cheque. Now, it was known to the Sheikh Khaled that he was presenting a cheque which had been replaced because he had
Mr.
requested...
Robert?
My Lord, yes.
Sorry to interrupt you again. The breaches which you refer to, it's under side agreement, correct?
Well, they're under both. They're under the side agreement and the shareholders agreement.
Okay. Which has a jurisdiction clause.
Both of which have an exclusive DIC jurisdiction clause, my Lord, yes. So we say to present the old cheque, which had been replaced, and the new cheque on the same day was obviously a breach of his duty of good faith under clause 11.4 of the side agreement, and his duty to make best endeavours to promote the interests of the company under clause 11.5 of the shareholders agreement. The cheques there's no obligation. I mean, this is a curiosity of my learned friend's submission. He says these are provided under the lease. There is no obligation under the lease to provide cheques. The cheques were provided by Mr. Sharma out of his goodwill in order to assist. All that's required under the lease is payment of rent in advance. He provided the cheques as an act of goodwill in order to facilitate the Sheikh raising finance to fulfill his obligations under the lease to build property, to build the second building. So in circumstances where Mr. Sharma has, in good faith, provided, without any contractual obligation, those cheques, for those cheques then to be abused and to be presented in bad faith as a means of presenting criminal complaints against Mr. Sharma and essentially driving him out of the country, we say is an extraordinary act of bad faith in breach of the side agreement and of the shareholders agreement. The second breach, we say, it relates to the intimidation of staff. And your Lordship will remember the events that are told in Mr. Sharma's statement, the complaints that the Sheikh made against 6 of the staff, resulting in their being detained in Ajman, the Sheikh's staff attending at the gates and seeking to interrogate members of staff, and the Sheikh himself seeking to interrogate security staff at the school. And we say those are clear breaches which are intended to intimidate staff, to create a climate of fear which will drive the staff away. The assets of any school are not only the building or the lease of the building, but the goodwill of its pupils, of the parents, and the loyalty of its staff. Now, once you start driving the staff away from a school, you are, let's be plain about this, you are in essence destroying the school. And we say that's in breach of the provisions in both the side agreement and the shareholders agreement, reserving exclusive management powers to Avalon Global. We say it's in breach of the provisions against interference in the management of the company, which are, again, both in the side agreement and the shareholders agreement, and in breach of Sheikh Khaled's duty of good faith and his duty to use best endeavours to promote the school. Plainly, it is a breach, we say, of all of those provisions of the side agreement and the shareholders agreement. The third breach are the allegations made by Sheikh Khaled to third parties. Again, not contested by the Sheikh at this hearing date, this return date. So essentially, Sheikh Khaled made allegations of neglect and of indiscipline in respect of the school in which he was the majority, nominally the majority shareholder. So those were, we say, implied misrepresentations. They were, insofar as he alleged that he was the owner of the school, a breach of trust. And the relevant trust arises, it's a contractual trust arising under the nomineeship provisions in the side agreement, and he essentially denied his own trusteeship, which is a clear breach of trust. It's a breach of the express duty of good faith in the side agreement, and it is, in terms of tort, it's an unlawful interference in the contract, contrary to the DIC law of obligations. The contractual relationship between the school, Avalon Heights, and the parents. Fourthly, his revocation of the power of attorney. Well, there is an expressed provision in the side agreement, clause 2.4, that the Sheikh shall provide a power of attorney. That, after all, is what gives Avalon Heights, Avalon Global, its exclusive powers of management. And similarly, in the shareholders agreement, there is an express promise by Sheikh Khaled that he will sign any document that requires to be executed. So we say it is a basic document. It's a document which Sheikh Khaled is required to maintain and to sign and maintain under both of the commercial agreements. And what he has done in publicly publicising a notarized notice that he was cancelling the POA, that was essentially a grenade intended to destroy the operations of the school. A further breach, we say, of his duty of good faith, a further interference in the financial management of the school, contrary to both the side agreement and the shareholders agreement, and a breach of trust contrary to the nomineeship arrangements that arose under the side agreement. So clearly a breach of duty under the relevant commercial agreements. Lastly, freezing the working capital facility. Any school, in order to run, needs working capital. It needs a bank account, and that was provided by ASEED. It is presented by my learned friend as a loan. In fact, it had an overdraft. It had a maximum overdraft of 4.5 million dirhams. So it's not a significant loan in terms of the value of the company. On the audit accounts, we've seen that the value is roughly 10 million dirham. It is a facility out of which the expenses of the school are paid, the staff salaries are paid, from which the school is run, as Sheikh Khaled well knows. Now, he wrote a letter to ASEED essentially saying that he would accept no liability. We say he had no liability anyway. He is a shareholder. It's a function of the principle of corporate separate legal personality that he didn't have any liability as a 51% shareholder. And again, in terms of breaches, we say that's a breach of trust, it's a breach of the exclusive management powers of Avalon Global, it's a breach of the undertaking not to interfere, it's a breach of the undertaking of good faith, and it's a breach of the undertaking to use best endeavours to promote the school. All of those are obligations and undertakings that arise under the commercial agreements, under the side agreement and the shareholders agreement. It's from this campaign that the court gave the school and gave the claimants protection from measures which we don't shrink from saying were vindictive and destructive in seeking to destroy the school, in seeking to persuade Avalon Global to give over control of the school to Sheikh Khaled. We say that those sorts of provisions are very common, the provisions in the side agreement with shareholders, for foreign investments who want commercial arrangements. They want those commercial arrangements under DIFC law. They want them decided by the DIFC courts, which they believe to be effective and efficient in providing justice. And this court should not drive them away in denying them the protection that they sought in those agreements. Now, the challenges that are put forward in terms of the injunction made last time by your Lordship. The first of these is the obligation of full and frank disclosure. Obviously an argument which your Lordship sees raised in terms of every ex parte injunction on a return date. In our submission, this is something of a sideshow. Either there is an issue as to jurisdiction, there is no arguable case, or there is not. If the court does not have arguable jurisdiction, then the injunction should be set aside, regardless of any allegations of full and frank disclosure. The reality, of course, is that that's not the case. Clearly, it is arguable that the court has jurisdiction. And in this case, the judge, your Lordship, immediately raised the issue of jurisdiction. My learned friend sought to spin my submissions and summarise them or characterise them. They do bear reading again. They're in the transcript, which I think is in tab 6 of my learned friend's bundle. Essentially, tab 6, my lord, page 3 through 6. So there's 3 pages of transcript dealing with the very points that my learned friend has raised, which were raised by the judge, your Lordship, on the first time this was raised. And that's to say the issues arising out of the memorandum of agreement, which is subject to the UAE companies law, is implicitly subject to UAE law, and indeed is expressly subject to UAE law. That is something which your Lordship, on your Lordship's reading the papers, had picked up on, because those documents were included, were exhibited, and were plainly referred to and relied on. So there we have that issue raised squarely. That is an issue which your Lordship raised, which your Lordship considered, and which on page 6 your Lordship decided that I, as counsel for the claimants, could go ahead in terms of arguing the breaches of the commercial agreements and the prejudice that arose on those breaches, on which we relied in seeking and obtaining the interim injunction. And then in terms of the lease, well, my learned friend took you to the right point, but it's important in dealing with it to make clear that it is very clear from what I said that the lease provides in terms of proper law and in terms of jurisdiction, and both of those are expressly raised, that is a matter of Ajman law. There's no attempt to conceal that or to mislead the court in that respect. And indeed, given the background, given that Article 31 of the 32 of the Civil Procedure Code, which provides that leases are subject to the jurisdiction of the territorial court, if I can call it that, that would have been entirely unsurprising to your Lordship. Your Lordship is well aware of all of the cases where parties have attempted to take their leases out of the jurisdiction of Dubai and write them under DIFC law or DIFC court jurisdiction. And the court has consistently, the DIFC court has consistently said, no, under Article 31 of the CPC, you can't do that. And therefore, if the relevant flat is in onshore Dubai, it's the onshore Dubai courts that have jurisdiction. The DIFC courts do not have jurisdiction. So that principle of the territorial jurisdiction in relation to real property issues is well known anyway. And so what we were saying in respect to the lease is entirely consistent with what everyone would know in this jurisdiction is the position. And then in terms of the skeleton, well, clearly we identified what we said were the relevant agreements, and we said the collaboration agreement, the shareholders agreement, the side agreement. They were relevant insofar as the claimants alleged breaches of those agreements. They are relevant because it is in those agreements that there is an express provision for DIFC, the exclusive jurisdiction of the DIFC court. Now, on the basis of that fact, the pleaded breaches and the exclusive jurisdiction clauses, we say it is then clear that there is a serious question as to whether the DIFC court has jurisdiction. So that is the point at which we said there is no sensible argument that is not the case. And that is the point that we were making in the skeleton. In respect of jurisdiction more broadly, as I've said, the test, both last time round and on the return date, is there a serious question as to whether the DIFC court has jurisdiction? And we say the answer is clearly yes, given those exclusive jurisdiction clauses in each of the relevant agreements. We add to that, however, that as a matter of English law, where an injunction is being sought, the court in many cases assumes jurisdiction, even if it knows that there is a jurisdictional challenge. And we rely in that respect on a case, Grupo Torres, which is in the second of the authorities bundle, if your Lordship has that.
In which tab?
Tab 9, my Lord.
The case is Sheikh Fahad al-Subah case?
Yes, that's right. So it's an odd decision. It was reported in 2014, but actually it was reported 20 years late because it was realised it was such an important decision that hadn't been reported. And the relevant passage, a decision of the Court of Appeal in England, is at the bottom of 643. So picking up the last paragraph, but ultimately one has to return to legal principle. For my part, I would accept Mr. Vida's submission that since an interlocutory injunction may be granted on assumptions of fact and law, it follows that an interlocutory injunction may be granted on an assumption that there is jurisdiction. That is so in respect of the inherent jurisdiction to grant a disclosure order. Similarly, it's so on the basis that the disclosure order is adjectival to the statutory power contained in Section 37(3) of the Supreme Court Act to make a worldwide moreover injunction. And the statute contains no hint of the legal principle advanced on behalf of Sheikh Fahad. So that makes clear the point that the court is entitled to make an assumption of jurisdiction. if it's necessary in order to prevent the injunction being rendered invalid or useless. But in any event, my Lord, we say the court doesn't need to rely on that assumption, because we say it's plain that it's plainly arguable, or it's plainly a serious question, that the DIFC court has jurisdiction, given the relevant breaches and given the express exclusive jurisdiction clauses. Now, then, the way that the particular arguments that my learned friend relies on are three, and I'll deal, if I may, with each in turn. First of all, he alleges that the Memorandum of Association has precedent and I should start by saying there is absolutely no authority, either cited or that we can find, which suggests there is any such precedence afforded to a Memorandum of Association. So the idea that we should be shut out of arguing that the exclusive jurisdiction clauses in the commercial agreements apply on the basis of an assertion of precedence, which is supported by no authority, we suggest is entirely, completely wrong. We say the Memorandum of Association, the company's constitution, and the side agreement and the shareholder agreement, the commercial agreement, which exists on a different level in respect of the commercial relationship, are different agreements doing different things. Now, clearly, my learned friend is right insofar as he asserts there is some overlap. There's some overlap between Article 9, which appoints Mr. Sharma as a manager, and between all of the provisions in the side agreement and the shareholder agreement, which reserve exclusive power of management to Avalon Global. But clearly, the provision in the shareholders agreement in reserving exclusive management powers to Avalon Global is a much, much broader, much more powerful provision, much wider than the powers of the managerial appointment, if I can call it that, in the Memorandum of Association. There is no suggestion of any precedent of one jurisdiction clause of the other, or indeed of one of those managerial provisions over the other. To the extent that we plead a breach of the shareholders agreement, we say that claim is entitled, we're entitled to bring that claim, and indeed we say we're required to bring that claim in the DIFC court. If anything, if there was any precedent, which we don't accept there is, it would actually be the other way around. If one looks at the shareholder agreement, so I don't know if your Lordship has that to hand. And if one looks at clause 15 of the shareholders agreement, particularly clause 15.1, in case of any conflict between any of the provisions in this agreement and the articles, the provisions of this agreement shall prevail, and the shareholder shall procure, at the request of any of the parties, such modification of the articles as shall be necessary to cure such conflict. So there is a clear provision that the shareholders' agreement, in fact, prevails over the Articles of Association. And similarly, in the side agreement, at clause 3.4, we find a very similar provision. So we find 3.4, in the event of any conflict or perceived conflict between the provisions of this agreement and the MOA, the provisions of this agreement shall prevail as between the parties, and the parties will use best endeavours to amend the MOA to accord with this agreement. So there we have...
Sorry, Mr. Robert. If I put in the all four agreements in order, then the MOA agreement comes first, then the lease agreement comes second, and the shareholder agreements come third, and the last, which number 4, the side agreement, which contain all provision and refer to the previous 3 agreements. So both parties, they are aware of the terms of the last agreement. Correct?
Yes. I mean, clearly, if you're dealing with legislation, there's a doctrine of implied repeal, i.e., if there's a conflict between legislation, the most recent statute is presumed to be the authoritative one. And we would say similarly in respect of a contract, the most recent contract is likely to reflect the actual intention of the parties, insofar as they may be taken to have departed from the provision in their earlier contract. So actually, if we're having an argument about a discussion about precedent, which we say is an argument not for today, all we have to show is that our case is arguable, that actually the precedence of the commercial agreements is established not only on the terms of those commercial agreements, but also on the fact that they are the last agreements in a sequence of agreements.
Continue.
And my lords, in respect of, if we could just look too at clause 3.3 in the side agreement, so the previous clause to the one we were just looking at, the MOA is the constituent document that sets the company and shall have the characteristics set out therein. To the extent that the provisions of this agreement are not incorporated in the MOA, the same shall be enforceable as a matter of private contract between the parties. So essentially, it's made clear that there are freestanding commercial obligations which exist and are enforceable as a matter of private contract. So the draftsman of this contract has before him the memorandum of association and is seeking to set up the side agreement as a freestanding private contract, commercial agreement, if you like, which determines the relationship between the joint ventures, the shareholders. And I should say too that even without those provisions, even without the precedence that's provided under the express terms of the contract, as a matter of common law, where there is an overarching agreement dealing with a joint venture, the jurisdiction clauses and the provisions of that agreement override those choice of law and jurisdiction provisions in a subsidiary agreement. And the authority for that is in the second authorities bundle, to which I took you a moment ago, Lords. And if your Lordship has tab 11 in that bundle, we have a case, Canon Charitable Trust and Serco. And my Lord, if I could take you to page 12 on the internal pagination of that authority.
Yes.
Thus, where
Which
different
paragraph?
but related... Sorry, the second paragraph, the first new paragraph at the top of page 12. Thus, where different but related agreements contained overlapping and inconsistent dispute resolution clauses, the nature of the claim and the particular agreement out of which the claim arose ought to be considered. Where a claim arose out of or was more closely connected with one agreement than the other, the claim ought to be subject to the dispute resolution regime contained in the former agreement, even if the latter was, on a literal reading, wide enough to cover the claim. So that's saying that if your breach is alleged under one agreement, you are entitled to rely on the jurisdiction provision in that agreement, which, in my submission, is an uncontroversial proposition. And then if one turns on to page 14 in the same authority, and there is an overarching joint venture agreement, and then there is a charge, a very specific charge that arose under the joint venture. And at paragraph 20, the judge says, the charge only arises for the purpose of implementing part of the joint venture. It is plainly subsidiary to the agreement, pausing there, the joint venture agreement. It is a more technical document, partly because of its nature, but also because it was drafted by lawyers. The inclusion of a clause providing for a choice of law was clearly necessary, as the charge could only sensibly operate within the confines of English property law. Pausing there, we would say the same for the lease. But the trigger for liability to repay the sum secured did not need to be underpinned in this way. The inclusion of a boilerplate provision for the court to have non-exclusive jurisdiction cannot have been intended to oust the very particular forum for the resolution of disputes chosen in the agreement. The court has jurisdiction, but only when either the jurisdiction of the arbitral tribunal is exhausted, or the court is needed to assist the parties or the tribunal in the arbitration. So there, providing as a matter of common law for the overarching joint venture agreement to take precedence over a particular joint choice of jurisdiction in a charge, a detailed document arising under the joint venture. And we say, my Lord, finally, on this issue, that if it were the case that every commercial agreement relating to a joint venture in Ajman or in any emirate was necessarily subject to the jurisdiction of the relevant company, the joint venture company, that would be a commercial absurdity, because it would mean that commercial investors in the Emirates couldn't require that their commercial relationships be governed by anything other than the law of the relevant emirate in which the joint venture company had been incorporated. And we say that would be an extraordinary decision as a matter of law, would have major implications more widely in the UAE, and we say for that reason would be wrong. In any event, we say that the Memorandum of Association provides for the jurisdiction of the UAE, the relevant relevant UAE court, or the UAE court with jurisdiction. And Your Lordship will remember the Arabic text in respect of Article 22, which refers to the court, the department with the relevant jurisdiction. We have in our bundle at tab 10 the decision of this court, the DIFC court, in Standard Chartered Bank and IGP Investment Group Private. That was the order of Justice Sir David Steele. And perhaps worth looking quickly at paragraph 4. Clearly, Your Lordship will be familiar with all of the federal and Dubai legislation which sets up the establishment of the DIFC courts, and pursuant to which it is said that the DIFC court is both a Dubai court and indeed a federal and indeed a UAE court. But this is paragraph 4 here as a neat summary of the relevant principles. There was some suggestion on behalf of IGPL that the DIFC courts were not one of the courts of the UAE, but any such contention would be misconceived. The DIFC courts is one of the courts of Dubai, see National Bonds Corporation and Ta'aleem. By extension, it is a court of the UAE. Indeed, within Dubai, it has exclusive jurisdiction. Accordingly, absent an agreement to accord exclusive jurisdiction to another court, there is no basis for excluding the DIFC courts as a court of the UAE. It is thus a court of competent jurisdiction in respect of claims under the 2009 agreement. We could read more of this judgment, but in my submission, that's enough to establish the relatively clear proposition that the DIFC courts are in fact courts of the UAE, and if they have relevant jurisdiction, we say under the professional agreement, under the commercial agreements, then they are the relevant UAE courts for the purposes of the memorandum of agreement. So there are numerous, but there are a number of bases on which we say, in fact, it is the commercial agreements that take precedence over the Memorandum of Association. And even if we're dealing with the Memorandum of Association, that in fact provides for the relevant UAE court, which we say is the DIFC court. Secondly, my learned friend relies on the lease agreement to seek to establish the jurisdiction of the Ajman court. We've looked at Article 32 of the Civil Procedure Code. That relates specifically to issues relating to real property. And of course, the provision in the lease article is dealing specifically with issues of real property, and it's in there precisely to be consistent with Article 31 of the CPC. Now, there is some overlap between the claims as pleaded under the commercial agreements and the background allegations that are, for example, in respect of the failure of Sheikh Khaled to build the second building. Those, I should say, are not part of the pleaded case. They're not part of the breaches that are alleged and in respect of which the claimants seek relief from the court. There's mention and there's some reliance on the covenant of interrupted enjoyment, but that is very fleeting and passing reference. What is relied upon here, what the primary case of the claimants here, is that there has been interference in the management of the company, not interference with the claimant's enjoyment of the property under the lease. Reference is made also by my learned friend to the presentation of post-dated checks. We say that is in breach of the duty of good faith under the side agreement. It's in breach of the obligation to use best endeavours to promote the company under the shareholders agreement. And we say it was done by the Sheikh knowing that the relevant Emirates NBD checks had been replaced, and he had vindictively presented 2 checks on the very same day. And indeed those checks have been provided voluntarily without any contractual obligation. We say that is an outrageous breach of the duty of good faith that was owed by Sheikh Khaled. So we say that breach arises too under the commercial agreements. Thirdly and lastly, in seeking to oppose the continuation of the injunction, my learned friend refers to the arguments of forum non-convenience. Well, I've made my submission about the Civil Procedure Code, the CPC. It is clear in our submission that that is a mandatory allocation of jurisdiction. It was put by my friend that there was essentially a discretion as to whether to provide. That is, in my submission, wrong as a matter of construction and wrong as a matter of law. The language is clearly of 31(5) of the CPC is clearly mandatory. There is no room in our submission for any discretion on the part of the court. There is no, second point, there is no doctrine in any event of foreign non-convenience within the UAE, where the rival jurisdiction is also within the UAE. That principle is very familiar in terms of disputes as to jurisdiction between the DIFC and onshore Dubai. We know that foreign non-convenience doesn't apply in that context. But it's also the case that it doesn't apply where the rival jurisdiction is another UAE jurisdiction. And we get that from the IGP case, which is behind tab 12 in my authorities bundle. In the second of the 2 authorities bundle. And then if I could take your lordship to paragraph 181 in that judgment.
Yeah, I'm familiar with this case.
Good. So 181 to 183, your lordship will be familiar. That refers to the judgment of His Excellency Justice Ali Al-Madni in the Allianz case. And clearly, the point there is that there are constitutional arrangements for the allocation of jurisdiction under the UAE Constitution and by the Union Supreme Court. And where there are those provisions as a matter of UAE federal law, there is no room for discretion on the part of the DIFC court. And finally, in terms of reference, if one turns to paragraph 195 to 197, makes that point far more eloquently than I can, or than I have. And my lord, finally, on this foreign non-convenience point, we say that even if foreign non-convenience did apply, even if we were wrong, one is looking in foreign non-convenience at practical issues, practical problems in holding a trial in a particular court. And we ask rhetorically, can it really be said that there are practical problems in getting witnesses from Ajman to the DIFC? Can it really be said there are language issues, given that most of the documents in this case are in English, given that the DIFC court is a court which functions in English? And can we say, is there any procedural dislocation or inconvenience in deciding issues under the commercial agreements which arise as a matter of DIFC law? But even if the principles of foreign non-convenience applied in this case, which they don't, even if they did, the connecting factors in our submission point quite strongly to the DIFC as being the appropriate jurisdiction, the convenient or the appropriate forum. The last point which my friend raises is in respect of the balance of convenience. Now we say, as your lordship will have understood, that if the court were to set aside this injunction, it would lead to irreparable harm to the school and to the company. The school would be destroyed, or there would be a strong likelihood of the school being destroyed. Staff would be driven away, pupils would drift away. The power of attorney is essential in order that this school can be managed in accordance with the commercial agreements. And the ASIL facility is equally essential in terms of the management of the school. Any school requires a bank account by which it is to run and to function and to pay salaries and to pay its bills. So that is, with that, in terms of balancing, that we say is a huge prejudice if this injunction is now lifted at this point. If, on the other hand, the court continues the injunction, we say there is no prejudice. We say that in part, perhaps slightly cheekily, in noting that there has been no compliance in any event with most of the obligations under the existing injunction. So the suggestion that there has been prejudice by reason of this injunction is in one sense, a slightly extraordinary submission. As for the prejudice which would arise if Sheikh Khaled deigned to comply with the existing injunction of this court, first of all, in respect of the post-dated checks, we dispute that he does not have the checks. The evidence suggests, or the evidence which we will be adducing, suggests that he has in fact cashed 2 of the checks, or presented 2 of the checks. So he does have possession of the substituted, the old checks. If we are wrong in that, and if the defendant cannot, does not have the checks and cannot secure their return, then there would be no prejudice, because the injunction cannot bite. He cannot deliver up checks which he doesn't possess, or which he doesn't control, or which he cannot recover. The reality, we say, however, is that he does have the checks. The reality, too, is that if he needs to provide new security for what is in effect his own borrowing to improve his own property, he can do so by providing his own checks or his own security. We say there is nothing to prevent him providing such alternative security for his own obligations under the finance agreement that he, in effect, has with the Ajman Bank. In terms of the risk to the defendant, to Sheikh Khaled, posed by a reinstatement of the bank facility, the ASEEL facility, which is a 4.5 million dirham facility, we say it's not at all clear that there is a personal recourse against Sheikh Khaled. There's no guarantee that has been provided for him. It's not alleged that there's any personal guarantee that has been provided for him. If one looks at the ASEEL facility agreement, as my learned friend invited you to do, and I would now invite you to do again, one goes to page 147, which is the finance agreement.
Remind me the tab again, please.
Sorry, I don't have tabs, my lord, so I'm not going to be able to help you on that.
I think
Mr. John,
I think will be tab 4.
It's tab 4 if it's under.
Yeah. And will be page 149.
well, so just starting. I have the facility letter itself. Does your lordship have that? I have it at page 147.
Your Honour, if you're looking at the claimants bundle, tab 4, page 147.
47. Yes.
I'm grateful. So here we have the facility letter sent to Avalon Heights, and I should say the second paragraph, just picking up the 4.5 million dirham, so that's the extent of the facility. And then your lordship has Schedule B, page 150, the security. Now, I should say that most of the security is security provided by Mr. Sharma and his family. So, for example, number 1, a first-degree mortgage on plot number 327 in Dubai in favour of ASEEL Finance. And secondly, one has irrevocable personal guarantees at 2. So guarantees provided by Mr. Sharma and by his daughter. And then at 4, a general assignment of receivables. 5 by Avalon Heights. 5, an undated cheque. And then 8, an assignment of a takaful life assurance policy of Mr. Sharma. And behind Schedule B, one has relevant documentation. So one has here the title deeds in respect of that apartment in Dubai. So the title deeds are held, and that's Mr. Sharma's own apartment, so that is held by way of security. And then one has a takaful contract at page 154 and following, and that is the insured, again, is Arundhati Vijay Shetty. That, I believe, is his daughter. So the exhibited security is, in fact, security provided not by Sheikh Khaled, but by Mr. Sharma. I should say the defendant's evidence will be that, sorry, the claimant's evidence will be that the defendant knew all about the Asil facility. My learned friend made the submission that it goes without saying that the Sheikh was unaware. Well, with respect, that submission is entirely wrong. We say, and our evidence will be on the jurisdictional challenge, that Asil met with both Mr. Sharma and Sheikh Khaled at the school site, and there was an agreement that Asil would provide finance to the school. And we say the facility is plainly within the scope of the power of attorney. The power of attorney gives Avalon Global a power to open and operate bank accounts, which we say is essentially what this facility is. As for the assignment of the lease, which my learned friend suggested was a facility, and he suggested it in very careful terms. He said, it seems that an assignment has taken place. Now, my lord, our understanding is that an assignment under Ajman law would be by way of a long mortgage and would therefore be registrable against title to the lease. So if it were the case that a lease had been assigned, first of all, one would expect it to be exhibited to Schedule B with those documents, but also one would expect to see it on the register. So that, we say, is why my learned friend had to make that suggested submission in such tentative terms, because the reality is that such an assignment has not taken place. So there is no exposure to the lease, which one should add. The lease is in fact the property not of Sheikh Khaled. The lease is the property of Avalon Heights. So that, to the extension to suggest that somehow creates prejudice to Sheikh Khaled is in itself curious as a matter of law. We say there is no risk or substantial prejudice that is threatened to Sheikh Khaled. Even if there were any risk, my lord, there is clearly an undertaking, a cross-undertaking to make good any damage. Your lordship has seen the balance sheet of Avalon Heights. The net assets, the audited net assets last year were 10 million dirham against a facility of 4.5 million dirham. So one would have thought, even if the value of the company had been slashed by half by the misconduct of Sheikh Khaled, that there is ample cover in the value of the company. But even if there weren't, Mr. Sharma is in the jurisdiction. He has posted a bond, as we understand, of 1 million dirham, and his passport has been surrendered. So there is no risk, as my learned friend seeks to suggest, that there is any risk of Mr. Sharma absconding. And he is clearly a man of assets, insofar as he's had to post a bond of 1 million dirham. Thirdly, in terms of prejudice, or an attempt to allege prejudice by my learned friend, it said that the injunction could be read widely as an anti-suit injunction. Well, I have 2 comments to make on that. Firstly, it is not so read by the defendant, because the defendant has in no sense or in no way sought to stop or cease its actions, its applications in Ajman that have failed in the Ajman courts, and which it now seeks actively to appeal. So that is not how the existing injunction has been treated or considered by the defendant. Secondly, that is not currently how it is treated by the claimant, and you will have seen in the further relief application that the claimant seeks, by way of further relief, precisely the anti-suit injunction which it needs in order to prevent the Sheikh pursuing parallel proceedings in Ajman, in breach of what we say is the clear exclusive jurisdiction clauses in the commercial agreements. So we say all of the attempts by Sheikh Khaled to suggest that there is prejudice, or any real prejudice, fail. There is not a hint, we say, of the irremediable harm that would be caused to the school and the company if the injunction were to be dismantled, to be set aside. That is why we say the court should now continue the injunction. We say that given the lack of compliance, the court should go further and impose some discipline in terms of requiring compliance by Sheikh Khaled. We say that might be, for example, allowing an early listing of the contempt application. But we say the injunction should be continued now in the usual ordinary form until trial or further order. Clearly, if the Sheikh Khaled succeeded in his jurisdictional challenge, that would be a further order, and the court could go back and revisit it. But otherwise, it should remain in place now until trial, and the court should make listing arrangements and timetable the proper evidence that will be required to be heard on all of the applications which now need to come before the court. My Lord, unless I can assist you further, those are the submissions for today.
Thank you, Mr. Robert. Yes, Mr. Stephen, you want to add something?
Yes, Your Honour. If I may come back as briefly as I may on a few points, dealing with them as they arose. First, my learned friend made some very strong submissions regarding these service of the jurisdictional application, and said that it was waited until last minute to be served at 5 p.m. I think he says yesterday. Simply, Your Honour, that's not correct. The application was issued on the 5th. It was served by email later that day. It was subsequently sent by courier and sent by email again. But it was a matter of hours, at most, from the point of application to it being served. The second, perhaps more importantly, an attempt is made by my learned friend to suggest that Sheikh Khaled has made no attempt to deny the conduct as alleged before this court. And all due respect to my learned friend, but that is simply an untenable submission, which would be readily apparent if he had read Sheikh Khaled's witness statement, assuming that he has. That includes denial of many of the allegations, indeed some of the more serious, including the wild submission that he's seeking to somehow pull on the levers of power in Ashman and to influence important people there. Frankly, ludicrous allegations which are made, and Sheikh Khaled quite rightly reserves the right to be more fully in response to those allegations at a point where this claim has been properly particularised by the claimant, if we even get that far. We do not consider that the court's time is best spent litigating the merits of the case during this hearing, which is focused on whether or not the injunction should continue. I don't want to address the court any further than that, but if I may turn to the substance of the injunction application. A point was made by my old friend about the post-dated checks. Alleged that these had nothing to do with any agreement whatsoever. I think his precise quote was that they were given without any contractual obligation. Yet surprisingly then seeks to allege that the provision of these checks and the encashment was for some reason a breach of the bad faith provisions of the side agreement and the shareholders agreement. With all due respect, it's submitted that this submission makes no sense. The claimants effectively want to have it both ways. And if indeed they did want to rely on some argument about an allegation of a breach of good faith, then presumably, given that these are checks provided for rent, this would be under clause 6.4 of the lease agreement, not the side agreement of the shareholders agreement. I can take Ron to those provisions, but if you look at clause 6.4, the usual provisions about good faith are set out there. This has nothing to do with the shareholders agreement or the side agreement. These are rent payments. The third matter I wish to address the court on is some submissions in relation to the sealed facility. In particular, one claim by my learned friend that amount of any borrowing under the sealed facility is insignificant compared to the value of the company. Then proceeded to suggest that it was 4.5 million, where the company was worth 10 million. Suggests that it can't properly be sustained that almost half the quoted value of the company is in borrowing to say that that's insignificant, that it poses no risk to Sheikh Khaled. Clearly that's not the case. Fifth, I'd like to address the court on the 1994 English Court of Appeal case referred to by my learned friend, the case of Torres. Your Honour, you will note that that case related to a worldwide Muhairi injunction. whilst the facts of that case might have made all the sense in the world to assume jurisdiction where the injunction is intended to have effect worldwide, then perhaps it made sense in that case, but none of those considerations apply at present. This is not a worldwide injunction. Your Honour, I also seek to refer you to clause 15.1 of the Shareholders Agreement, which is at tab 4, page 150. This is a point which was raised by my friend in relation to precedents. He sort of suggests that, if anything, the precedents of contracts were in favour of the claimants, and that it's the shareholders' agreement, the side agreement that take precedence. But I'd ask the court to read that provision more carefully. So clause 15.1, in the case of any conflict between the provisions of this agreement and the articles, provisions of this agreement shall prevail. But importantly, it says the shareholder shall procure, at the request of any of the parties, such modification to the articles as shall be necessary to cure such conflict. This entirely feeds into the defendant's submission that if this is to take precedence, it must be attested, notarized, registered in the correct way so that it forms part of the company's memorandum. Clearly that was envisaged by the side agreement and by the shareholders agreement. That wasn't done in this case, and therefore we reiterate our submission that the document which takes precedence is clearly the memorandum. And Your Honour, the final point I wish to refer you to, if you can look at page 150 of tab 4. This relates to some submission my own friend made in relation to securities provided. It also suggests that, I think in fairness he said most of the security is being provided by Mr. Sharma, and he took you through some examples of that. But perhaps to add to the court record the court's understanding of what these securities include, you'll see further examples at point 4. An irrevocable general assignment of the receivables of the school in favour of the sale of finance to the full facility amount supported by a list of receivables. We have 10, subordination of the school's shareholders' current account in favour of the sale of finance. 12, negative lane of all assets under Avalon Heights School to be submitted to a sale. The point is, whilst Mr. Sharma may have put up some security, as far as the sale are concerned, the Sheikh is a 51% shareholder of the school. By placing the school's assets in these securities, it's clear in our submission that the Sheikh bears a significant degree of risk in the event of default. Those are the immediate submissions I'll have at this time, unless I can give any further assistance.
Thank you, Mr. Stephen. Yeah, I'm ready to issue my order in regard to the application. After reading the application submission and documents and hear the both parties today hearing, I can say I'm satisfied with the applicant submission that the injunction order shall be continued with the current terms unless the party by consent submit to this court to amend the injunction order. This is as a point 1. Point 2, in regard the application of jurisdiction, again I invite both parties to collaborate and cooperate to find a suitable date to hear the application before this case, before this court. So I leave it with the party hand to fix a hearing date with the registry direction. The third point, the two applications which Mr. Robert referred to, I prefer also to hear it with the jurisdiction application together. So, and now the parties a duty to come with the time frame for the submission and the hearing date.
My Lord,
Any
can I make?
comments?
No. Yes, can I make two comments? Firstly, whilst we understand why the court has invited the parties to collaborate and cooperate, your Lordship will understand that there is a lack of goodwill between the parties, and there has been very significant difficulties in achieving collaboration and cooperation between the parties. And in those circumstances, my Lord, we would urge you to provide a timetable, and we would suggest that the claimant file and serve evidence by the 26th of June, the defendant file and serve evidence by the 5th of July, and that the matter then be listed, or the issues and the applications then be listed on the first available date after the 5th of July. So, my Lord, that's our first point in terms of timetable. So, claimant's evidence 26th June, defendant's evidence the 5th of July, hearing after the 5th of July. And then our second point would be, given the total lack of compliance to date with the existing injunction, we would seek a provision that the injunction be on unless terms. So unless the defendant complies with the existing injunction by we say the 10th of June, which is Sunday, essentially giving it the weekend, then the claimant should be at liberty to bring on their contempt application on an urgent basis. Because we say at the moment, most of the injunction is just being ignored by the Sheikh, and we say the court should act to allow the contempt application to be brought on if there isn't pretty prompt compliance now and curing of its contempt by the defendant. So, my Lord, we make those further applications.
Yeah, Mr. Robert, I believe before today's hearing, I think the defendant will be cooperate and collaborate actually with the claimant to enforce the injunction order, my injunction order. If not, then you move to the second scenario, which apply for the committal injunction, but I don't think so. It's on an urgent basis.
Well, my Lord, the order has a permission to apply. I wonder if we needed to come back to you on this because we weren't finding proper cooperation. We could apply in the letter to your Lordship, explaining the current circumstances and seeking any further relief necessary to, first of all, establish a timetable, but also deal with any contempt, if it be the case that the defendant continues to act in contempt of the DRC court.
Yeah, accepted. Yes, Mr. Stephen?
Your Honour, 2 points. The first is that, of course, the defendant opposes any suggestion that the terms of the injunction should be extended to include any unless order, so which clearly broadens the scope. The second request that the defendant makes to the court at this stage is that it consider revising the terms of 2 of the provisions of the injunction.
I understand. Earlier you raised this issue, and my answer to your question, I'm satisfied with the current injunction order, unless both parties, you and the applicant, reach an agreement or in consent that you want to amend the current injunction order. So will be remain as it is.
Yes, Your Honour. The final submission we have is in relation to directions for this dispute. First, the defendant submits that it's a matter of logic that the jurisdiction of this court is an overarching issue which has a bearing on the outstanding applications in this case. It's already been accepted, I think, by both parties that hearing is going to last a full day. In our view, it's logical for the court to first determine whether it has jurisdiction and then to proceed to hear further applications after that application has been heard. As was suggested, the outcome of the jurisdictional dispute may dispose of these proceedings in their entirety, and preparing for and hearing the other applications is likely to radically increase the costs borne by both parties. Those should be properly observed until after the jurisdictional dispute.
I think I make myself clear enough when I said the jurisdiction application and the 2 applications of applicant, yes, I can hear it together. So there's no harm to prepare both of you for that day.
Yes, Your Honour.
My Lord, that leaves
So,
only the timetable, my Lord, which I proposed. I don't know if that would be acceptable in terms of the serving of evidence by the parties and the window, if you like, for the hearing date.
Your Honour, I'll have to take the instructions. I think the easiest way to deal with this is likely to be the parties have a discussion and send their proposals to the court by email. If they disagree, those disagreements can be set out by both parties in that correspondence. I'm sure that it will be perfectly easy, given that these are procedural directions for the parties to agree.
Okay, fine, accepted that.
My Lord,
And regard
leaves
the cost, yeah,
My Lord,
sorry to intervene.
My Lord, so we
Go ahead.
say that we say that we have substantially succeeded. The injunctions have been continued. There's been an aggressive attempt to have the injunction set aside. That attempt has failed. And we say the logical consequence is a general rule in the RDC, that's to say that costs should follow the event. It's because costs follow the event that parties are deterred from taking bad positions, from making bad opposition to good applications of good injunctions. We say the defendant, acting reasonably, would have accepted the continuation of this injunction at least until the hearing of the jurisdiction application, and their hasty opposition, we say, has been an unnecessary inconvenience to the court today when the injunction should simply have been continued for a relatively short period of time. So in those circumstances, my Lord, we seek an order that the defendant pay the claimant's costs of the return date.
Yes, Ms.
And
You have a comment, Mr. Singh?
Also bear the costs, I should sorry to clarify, the costs of the injunction, because it follows if the applicant succeeds on the return date, that is also entitled to its cost of the application for the injunction.
Yes, Ms. Stephen.
Your Honour, for obvious reasons, the defendant contests that any cost order should be made at this stage. Of course, with these kinds of applications, particularly where the original application was made without notice, the normal position is that the court will only know whether or not the injunction is correctly granted once it's made a decision either on jurisdiction or on the merits, and that any decision costs should at least be deferred to them, or should be costs in the case. Further, one of the main reasons the defendant has been in attendance today was due to what it says were failings by the claimants to make full and frank disclosure, to properly air for the court's considerations the points that the defendant was likely to raise, and indeed was entitled to raise. Obviously, when it comes to these cases, the court has to make a decision, amongst other things, on the balance of convenience to the parties, but it still remains right that the parties should be able to present what prejudice will be suffered in a fair manner, and both parties to be heard. So it's on that basis we ask the court to determine the question of costs at the next hearing, where we'll consider the question of jurisdiction and the other applications.
Okay, as I decided that there will be a second round to hear the jurisdiction application, so the cost will be in the case, means after dealing with the jurisdiction application, will be my order in regard to the cost.
Sorry, could I just to clarify, costs in the case would mean that the party that wins the case at the end of the trial is entitled to this cost. I think what your Lordship is suggesting is that the cost should be reserved for the hearing, for the further hearing.
I'm suggesting, I'm suggesting that the cost will be reserved until final coming from the jurisdiction application.
So be it, my Lord. I'm grateful.
Thank you for coming both, and have a nice weekend.
All rise.